Okay. Good morning, everybody. We're going to get started. Thank you for joining us. I'm Ann Wolf from the Bar Association. I'm going to turn it over to David Pearson, who is the head of the, who's on the education committee for the bar and is going to do the introductions today.
All right, good morning and thank you for attending technically session number 5, although this is the 4th presentation since we've somewhat reordered things. As Ann said, we are recording this, so these will be made available actually shortly in the next week or two on the Contra Costa Bar website if you want to rewatch or if you miss anything. We want to remind everybody to make sure you have registered for this if you want MCLE credit. So some people have been able to dial in to watch these without being pre-registered, but you will not get credit if you don't register through the Bar Association. And our next seminar after this one will be on May 29. So we hope that those of you who are here keep attending the series. And throughout this panel, we'll be monitoring the chat window. If you have any questions, just post your question through chat so that the speakers can address your questions. And with that, I will turn it over to Diane Camacho, who's going to introduce the panel. And good morning, good luck.
Thank you. Thank you, David. Good morning. As David said, we will be monitoring the chat. I'd like to introduce our presenters today. Joshua Bevitz is a partner at Neumeyer Dillon in Walnut Creek. He advises developers, builders, contractors, and other businesses on a variety of real estate, construction, insurance, and cybersecurity related claims. He has experience litigating cases in both state and federal courts, resolving cases through alternate dispute resolution, and enforcing judgments. Jeff Dennis is also from Neumeyer Dillon, and he is the head of the privacy and data security practice. He's earned a designation of a certified information privacy professional in the U.S. private sector and as recognized by the International Association of Privacy Professionals. Jeff works with the firm's clients on cyber-related and privacy issues, including regulatory compliance, risk management, and cyber liability insurance. Ericka McKenna is a business law attorney. She serves as outside general counsel to small and mid-sized businesses, helping them with everything from entity formations and restructuring to contract negotiations to business succession planning. Ericka recently co-founded McKenna, Brink & Signority, and it's a boutique law firm in Walnut Creek focused on business, real estate, and estate planning. I'm Diane Camacho. I'm a legal operations expert. My company works with solo and small law firms on operations, legal management, and back office support. And we are going to talk today about the attorney's obligations related to cybersecurity and cyber attacks, data breach survival, choosing hardware and software, working paperless, communicating with your clients in a virtual world, and then we'll have some time at the end for questions. If there are questions, I will be posing them to the panel during and at the appropriate times during breaks and things. So we're going to get started, and Joshua, please begin.
Hi, everybody. Good morning. So as you can imagine, the frequency of cyber attacks on law offices are going to increase over time because all of our files contain, confidential and valuable data in them. In order to address that reality, the American Bar Association issued formal opinion 483, which clarifies an attorney's obligations to prepare for cyber attacks and to safeguard information provided to them and to respond appropriately if an attack occurs. So the opinion grounds itself in Model Rules 1.1, which is deals with competence, 1.4, which deals with communication, 1.6, which deals with confidentiality, 5.1, attorney supervision, and 5.3, non-attorney supervision. So the opinion states that lawyers must employ reasonable efforts to monitor the technology and office resources connected to the internet, external data sources, and external vendors providing services related to the data and the use of that data. In other words, an attorney must protect their electronic files. It goes on to state that a data breach involves the misappropriation, destruction, or compromise of client confidential information, or a situation where a lawyer's ability to perform legal services for which the lawyer was hired is significantly impaired by the event. And each of these scenarios is one where a client's interests have a reasonable possibility of being negatively impacted. When a data breach occurs involving or having a substantially likelihood of involving material client information, lawyers have a duty to notify clients of the breach and to take other reasonable steps consistent with their obligations under the model rules. And while the ABA rules are not technically binding on attorneys, states will likely issue similar rules, and so we should be prepared to follow the regulations. An attorney has legal duties that are separate from ethical duties, and as such, if personally identifiable information of a client is affected, an attorney should comply with privacy laws and other statutes, including notification requirements, which we'll go over a little bit later. So first and foremost, ensure reasonable computer protections are in place, and that's centered on the duty of competence and confidentiality. As I said, model rule 1.1 competence. An attorney shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. And comment 8 to that rule says, to maintain the requisite knowledge and skill, a lawyer must keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology, engage in continuing study and education, and comply with all legal education requirements to which the lawyer is subject. And Model Rule 1.6 C says, lawyers make reasonable efforts to prevent the inadvertent or unauthorized disclosure or unauthorized access to information relating to the representation of a client. And the takeaway from that is that every law firm should have current technology protecting their computer systems, including those office resources connected to the internet as well as external data sources. So a firm's IT department should do periodic and regular reviews to determine whether additional protections are warranted and whether the current security system in place is, quote, reasonable. And the ethical duties hinges on this concept of reasonable. And so the IT department should also monitor for when existing patches are needed and necessary based on newly developed cyber attacks. So at least one technically competent partner should be assigned as the liaison to the IT department to ensure its responsibilities are being met. If a law firm does not have an IT department, an outside cybersecurity firm should be consulted and retained. So a successful cyber attack on a law firm or a lawyer's office does not necessarily mean an attorney has committed an ethical violation. Again, an ethical violation only results if the attorney did not take reasonable steps to protect its electronic files.
Hey, Josh, can I jump in real quick? Sorry to cut you off, but
no, go ahead.
One thing you mentioned is compliance with regulatory requirements that vary from state to state. In the state of California, it is important that law firms and really most businesses have quote unquote reasonable security under the California Consumer Privacy Act. To take a step back, if you're not familiar with the CCPA, as it is affectionately known, the question is, does it apply to you? Now, I understand that most of you on this call may be solo, small law firms, so it may not apply to you because the thresholds are fairly straightforward. For-profit business doing business in the state of California, don't necessarily have to be in the state of California. And if you are a for-profit business, you then must meet one of three threshold requirements. Either you have annual revenue in excess of $25 million, or two, you have stored 50,000 pieces of consumer personal information, or 50% of your business derives from the sale of that personal information. Now, for those of you on the call, those may not apply to you, but it is very likely that they apply to many of your clients. And so it's important that you understand, and your clients understand, that there are a wide array of obligations under the CCPA, including this notion, as Josh mentioned, of having reasonable security in place. Now, what reasonable security means under the CCPA, completely unknown at this point. Gotten very little guidance, if any, from the California Attorney General's office, but it's something that you need to be aware of because it is a complex law. There are a whole host of obligations that derive from it. So, Josh, back to you. Sorry for the interruption.
That was valuable. Thank you. Something else law firms should do is train their attorneys and their staff. And the ABA grounds this in Model Rules 5.1 and 5.3. Most cyber attacks are not frontal attacks on a network's protective structure. It's a result of human error. A staff member, an attorney gets a fake email with a link. They click on the link, and all of a sudden, a virus or malware is downloaded into the system. So all users should be regularly trained as to what type of cyber attacks occur, what's common, what attackers try to do to trick users. And so what my firm does, and what I think all law firms should do, is conduct fake phishing campaigns to test their employees. If you don't have an IT department, there's numerous third-party cybersecurity companies that can do that for your firm. Trial by error is often the best way to learn. As I said, my firm does it. We get fake emails that the IT department's trying to get us to click on. I'm happy to say I've only fell for it once, and it was because after this shelter in place, monitoring email through your phone is a little more difficult, and I got a notification that the court had set an OSC hearing, and if I didn't attend, I was going to get sanctioned, and I stupidly, in a panic, clicked on the link, and it was actually a fake cyber. Something law firms also need to do is ensure that third-party vendors have reasonable cyber protections in place. That's grounded on Model Rule 1.6. Again, the standard is reasonable. If a vendor does not have reasonable protections, you should require that vendor to implement such protections or retain another vendor that does provide such protections. Law firms can be held responsible to their clients if they do not ensure vendor security exists. One proven approach for law firms is to contractually require those vendors to adhere to a specific cybersecurity framework and to provide the law firm the right to audit them as to that framework on a periodic basis. One thing law firms can do to protect themselves and their clients is to limit the amount of time you retain client files. The longer you retain electronic files, the longer those files are susceptible to being attacked. And every law firm should have a written retention policy, which should be followed and monitored. That applies to both hard and electronic copies of files and documents. And one thing that you can do as well is the amount of time client files are retained after the conclusion of a matter should be limited as part of the initial retention agreement. And next, law firms should know how to respond if an attack occurs. They should have a plan in place to deal with them. That's grounded on Rule 1.1, which is competence. Having an effective comprehensive plan will allow a law firm to halt the attack, minimize any damage and disruption as soon as possible after the attack becomes known. The plan should specify each step that takes place and who is responsible for taking it. High-level partners should be assigned to the response team to provide leadership, permit executive decision-making to occur quickly. Moreover, the ABA opinion specifies that a competent lawyer must take all reasonable efforts to restore computer operations to be able to, again, service your clients in a competent way. And Rule 1.4A3 provides that a lawyer must keep the client reasonably informed about the status of a matter. Rule 1.4B provides a lawyer shall explain a matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representations. And in grounding those rules, the opinion states that notification requirements will depend on the type of breach that occurs and the nature of the data compromised by the breach. Notification to the client is required if material client information has actually been accessed, disclosed, or lost in a breach, or you reasonably suspect as much. And if your system is impaired and your duty to provide legal services is affected and you don't take reasonable steps to resume operations so you can advocate for clients effectively, that could be considered an ethical breach. So one of the key steps in the response plan is discovering what occurred, whether client data was compromised. And this step is vitally important so law firms can notify clients in a timely fashion if their data was taken or destroyed. It should be sufficiently detailed of a notification so that the client themselves can decide what next steps, if any, should be taken as a result of the attack. And also law firms should notify clients about any efforts to recover data and what additional protections, if any, are being put into place as a result of the breach. So the American Bar Association took a look at current clients and former clients and decided that the responsibilities to those categories are different. So attorneys should take the following actions in relation to current clients. Protect your computer system and ensure vendors are doing the same. Have an incident response plan in place to stop the attack and minimize damage. Conduct an investigation to determine exactly what happened and notify and advise clients as required. Now, former clients, the ABA treats them differently because the model rules don't address an attorney's duty to notify a former client of a cyber attack. So as to former clients, Model Rule 1.9c requires that a lawyer who has formally represented a client in a matter or whose present or former firm has formally represented a client in a matter shall not thereafter reveal information relating to the representation except as these rules would permit or require with respect to a client. So when electronic information relating to the representation of a former client is subject to unauthorized access, disclosure, or destruction, the model rules provide no direct guidance on a lawyer's obligation to notify a former client. And so Rule 1.9c provides that a lawyer shall not reveal the former client's information. However, it doesn't describe what steps, if any, a lawyer should take if such information is revealed. As such, the ABA did not require notice to a former client as a matter of legal ethics in the absence of further guidance. However, as mentioned, there are civil statutes which we'll go over in a minute, that would apply to former clients if their information is taken and it's in a certain classification of that information. So while it might not be an ethical breach, you might have civil liability as a result. If you don't take these 5 steps, you could be found to have breached your ethical duties and also lead to civil liability. So you have to protect yourselves, be proactive, and make sure you have reasonable steps in place to comply with your ethical duties. So in California, we have certain statutes that apply to all businesses. Cyber criminals are attacking all businesses, including small businesses. And the reason for that is that most small businesses do not have, the resources necessary to properly protect themselves. They don't think they have valuable data. They have weaker security. But unfortunately, 70% of cyber attacks do target small businesses. The dark web out there is collecting data on all of us and creating profiles of all of us, and they're collecting as much data as they possibly can. So while you might not think a certain piece of information regarding you is important, when everything is collected and collected together, each of those pieces becomes even more valuable, and that includes responses to security questions such as your first dog, where you met your wife or husband, etc. So Civil Code Section 1798.81.5 requires businesses to implement reasonable procedures to maintain the security of personal information that businesses store or disclose to third parties. If you want some resources to consult, the California Department of Consumer Affairs Office of Privacy Protection has released recommended practices on notice of security breach involving personal information. It covers protection and prevention, as well as procedures relating to data security breach notifications. Also, the Federal Trade Commission has issued a data breach response, a guide for business. It contains recommended steps to take once a data breach has occurred. So what should you do if a attack occurs? Contact an attorney who specializes in cybersecurity. Contact local law enforcement. And if it's within their jurisdiction, contact the FBI. You should also report the attack to a website that's www.us-cyber.gov. cert.gov, which is secure and it does not release confidential information without authorization. You should put any applicable insurance carriers on notice. Unfortunately, most CGL policies now exclude coverage for cyber claims, but you can buy a standalone policy. You should do so as soon as possible. And currently they are relatively inexpensive. So I highly recommend that you get one. And you should also ask your internet service provider if it can help you identify the IP address of the intruder and the areas of the website that have been compromised. All right, so very importantly, to protect yourself, you should comply with California's notification statute. That's 1798.82, and it applies if personal information has been stolen. And that's defined as a first name or first initial and the last name in combination of one or more of the following data when either the name or data are not encrypted. And that includes a social security number, a driver's license or a California identification card number, account, credit, or debit card number along with a security code, access code, or a password, medical or health information, data collected through an automated license plate recognition system. And also another category is a user's name or an email address in combination with a password or security answer, question and an answer. So you must notify the affected individuals of the following in writing or electronically in a form mandated by Civil Code Section 1798.82D of the following: what happened, what information was involved, what are you doing about it, and what can they do about it. You can use substitute notice under the statute if the cost of notification would exceed $250,000, or more than 500,000 people need to be notified, or the business does not have sufficient contact information. Email notice and a conspicuous website posting is an example.
Hey, Josh, if I could interject again, I think another statute that folks need to add to that list is, in addition to the data breach section 1798.82, is the California Consumer Privacy Act that I mentioned before. If you or your clients do meet those threshold requirements, it's important that you're complying and you're providing the notifications and the policies and all such things that are set forth in the CCPA. It's important not only to firms, but also to clients. There are massive privacy obligations, the cybersecurity requirement that we mentioned about reasonable security. I should have mentioned that this law is very new. It actually took effect on January 1 of this year. The California Attorney General has primary enforcement rights for privacy violations, and the AG enforcement actions can start on July 1st of this year with a look back to January 1st to see how companies have complied with the CCPA. But it's also important to note that if you don't have reasonable security and you suffer a breach and you are required to comply with CCPA, you have the potential for some very significant damages. The damages range for a data breach from $100 to $750 per piece of personal information that was breached. Now, it doesn't sound like a whole lot until you start doing the math. And it becomes even worse when you realize that the plaintiff, there is a private right of action only for the data breach section of the CCPA. There is no requirement to prove actual damages. And so obviously this opens the door for wide-ranging class action probability that I am sure we're going to start seeing more and more of in the coming days. So I think it's important to include the CCPA and add it to Josh's list of obligations that you have.
Yeah, that's right. And it's not just having a website hacked or your electronic files taken. An example is a dentist office. Someone breaks in over the weekend, takes all the credit card machines, and now has the patient's financial information. So if that financial information is used to the detriment of the patients, and reasonable security wasn't undertaken, and the notification requirements were not complied with, you could face significant liability if you end up getting sued by all these parties. And so part of the notification You should offer appropriate identity theft protection, prevention, and mitigation services at no cost if the breach involves individual's name, social security number, driver's license, or California identification number. And also, you must notify the Attorney General if more than 500 records have been exposed. One important reaction is to evaluate the damage, assess whether there's been physical damage to electronic files or hard drives, itemize and isolate every electronic file that has been stolen or damaged, compile evidence, including as to whether trade secret or proprietary information of the company, its employees, or its customers has been compromised. If financial information has been compromised, you must inform the company's bank. Memorialize information related to network downtime and impairment of service to customers. Keep a record of the costs. You should track the remedial work performed, including the time spent and the costs incurred. And expenses incurred relate to third-party consultants, loss of productivity, loss of profits, and hardware and software costs, and analyze the cost of recovering the lost data. You should make sure evidence is preserved, isolate the server to preserve potential evidence of the attacker's identity, ensure that the system is not automatically running maintenance or utility programs as they can recycle or delete important data, evaluate whether to hire a third-party consultant to preserve electronic evidence on a separate system, perform a backup of the system and save in a secure location without overwriting existing as to backup files that may contain critical evidence. You should not fix the damage until law enforcement can collect evidence. You should preserve network access logs. You should interview employees as they may have evidence of the identity of the attacker, such as a disgruntled employee or ex-employee. You should take the system offline as the attackers might be monitoring the system or attempting to cover their tracks. And if that takes place, you should post a notice of temporary unavailability of the website. Print copies of key information or evidence so it cannot be modified by the hackers. So key to all of this is reasonableness. Are you keeping up to date on current trends, current types of attacks, current software that can protect you from those attacks? Do you have a plan in place to respond to breaches? If those steps aren't taken, you could suffer consequences as a result of lapse of ethical duties and open yourself up to significant civil liability. Jeff, anything to add?
No, I think you covered it. I think, again, for under the CCPA in particular, which is what I've been focused on as I continue to interrupt you throughout the presentation, Josh, is, it all comes down to having reasonable security in place for cybersecurity and the data breach side. The CCPA does have an entire section. Most of it is relies or revolves around privacy obligations of companies, but those are clearly beyond the scope of this presentation. That's a, when we decide to do that, that's a several hour dissertation on the ins and outs of the CCPA, but no, I think you covered it, Josh.
Thank you. I do want to add that recently we had a client who didn't divulge client information. It was a law firm, but what happened was they were being attacked. Their third-party provider was being attacked. So the person that was hosting their information was being attacked. And so they basically unplugged the server from the wall. So there was no internet access. And our client was brought basically to their office a hard drive with all their information on it, all their accounting information and all their client information. So even if you don't have a breach of client information, because in this instance, nothing was actually breached because they stopped it, there are still things you should be doing. And cybersecurity is very important as far as covering the cost. Cyber insurance is very important as far as covering the cost. It took us about 2 months to get them completely back up and running. Their email was down for about 5 days, and we got them kind of working, stumbling along in about 5 days. But to get back to where they were. It took a good 2 months to get everything set up and get new servers in place and the security and all of that kind of thing. So it can really damage your ability to practice law and to respond to clients as well, even if you haven't had a breach. So this is all important no
Yeah.
matter what's happening with your information.
Yeah, I also want to mention that a lot of these insurance policies, they require you to take specific steps and hire specific consultants and companies in response to attack. And if you start taking actions without consulting them, you could jeopardize coverage.
Absolutely. The first thing you do is call your cyber insurance broker or somebody to get started. They will provide you with experts in the field. So we're going to move on to Ericka, and she's going to talk a little bit about her experience with opening her firm and kind of working it from the cloud. So here you go, Ericka.
All right, thanks Diane, and thanks Josh and Jeff, that was great. So yeah, shifting gears a little bit, I'm going to do more of an overarching discussion of technology as it relates to building a law firm, growing a law firm, etc. So a little background on me. I co-founded a law firm just recently, a little over 6 months ago. And when my partners and I formed this firm, we had a goal of forming what we envisioned to be a modern law firm. We wanted it to be lean. We wanted it to be as electronic and paperless as possible. We wanted to implement automation. We wanted to do things as seamlessly as possible with as little physical equipment that was needed. So I'm just going to go over some basics of what I experienced, and I'm happy to answer any questions as we go on. So one of the first things here on the list is actual computer equipment and IT. We just talked a lot about IT and the specifics of the law related to it, but in forming a law firm, what did I do? Full disclosure, I am not the most technological person. I don't know a lot about technology, but that's okay. You don't need to know a lot about technology in order to use technology to build your firm. You can do that by partnering and working with people who know what they're doing. So one of the first steps that we took was we partnered with an IT company. We took their advice as to what computer equipment do we need? What do we need from an ongoing standpoint? And what has been great about that in using an actual computer sales and IT company, all of the physical computer equipment that we bought, if there is ever any issues with it, they handle the warranty. They handle fixing it. We don't have to do anything. So that's one thing that's been great about actually working with a computer company. And from the IT standpoint, they are continually monitoring our systems. It's not just to monitor for potential attacks and things of that nature, but also to push all of our software updates that need to happen on a regular basis. If you aren't updating your software as new versions come out, it's going to cause problems in other areas. So one thing that's great about having a company is they do this for you. Moving on to photocopiers. We want to be paperless, but we're attorneys, and every now and then we have large print jobs. We need to print all of the discovery that's been propounded and things of that nature when it's necessary. So we did find that one physical piece of equipment that we needed was a large scale copier. And what we did is we engaged a copier company. We took their recommendations. They talked to us about what our printing jobs might entail, and they gave us recommendations of the copier we needed, and we leased a copier. So that's one piece of equipment that I found that we really did need, even being mostly paperless. As far as internet, there are a lot maybe not a lot, but there's several providers out there. The best thing that I found that we did is we actually engaged a sales rep from an internet company who is our go-to person. What's been great about that is whenever there are internet connectivity issues, we have someone to call to get it fixed. We rent a space in a large office building. And there have been times where the internet was down for the entire building, and tenants will be walking out, hey, is your internet down too? Is your internet down too? And I said, yeah, let me call our guy and see what's going on. And the response from our neighbors was, oh, you have a guy? We don't have a guy. We just call the 1-800 number and we stay on hold until we hear what's going on. So that's one thing that I really found useful, was actually partnering with a sales rep at whatever internet provider that you work with. Phones. We use Voip phones, so voice over internet protocol. I believe most law firms nowadays are using Voip phones. One thing that has been great about that is now that we are working remotely, we are able to seamlessly transfer calls to our office, from our office to our cell phone. And so it looks like we are calling from our office, or it looks like someone is calling our office, when really I'm on my cell phone in my house, and no one is any the wiser. So that's been great about using Voip phones. One cautionary tale that I will tell people, if you're forming a new law firm and if you are having Voip phones installed, our experience was it was a very long installation process. You can't just call and then expect the company to be out the next day installing Voip phones for you. It took several weeks to get it going, and that presented problems because, at least with the provider that we used, they cannot assign you a phone number until they are doing the install. And when you are trying to advertise a new firm, you want to be able to tell people what your phone number is. So just a cautionary tale that it does take quite a while to install Voip phones. All right, going to the next slide. I'm just reading the chat real quick to make sure no one's asking questions to me. It looks like people are asking questions to other people, so I will ignore those. Okay. Oh, David is asking a question. So David is asking what Voip service we use. We use Comcast. It was who we were familiar with, so it's who we went with, but it did take a long time to actually get it installed. Okay, moving on to software. So one thing that I've found in trying to create what we see as a modern law firm was we wanted to eliminate any unnecessary equipment. That included fax machines, that included postage meters. So everything that we do, if possible, is electronic. We use electronic faxing programs. We use electronic postage. We go to stamps.com and print out stamps. We, as everyone is doing nowadays, we use video conferencing. We use conference calls. We do as much as possible by eliminating physical equipment. Okay, now I'll just do a little tip, and many people may know this already. For conference calls, video calls, one tip that we are hearing is don't schedule your meetings on the hour or on the half hour. That is when these providers are bogged down because everyone is scheduling their meeting for 12 o'clock, and it's causing a lot of connectivity issues. So one tip that we got from our provider was to schedule things on, on the 15 or on the 45 of each hour. It doesn't roll off the tongue as easily, but if you're worried about connectivity, that's one tip that I've received. Okay, now I think we're gonna hop over to Diane and Jeff for the next couple of slides.
Right. So when we talk about security for our offices, and it doesn't matter how large or how small your office is, there are certain things that you should be doing with your computer equipment and your client information. And some of these things you've heard of and some of them you haven't, but this is basically what's called layers of security. So different things do different security, does different things and blocks different kinds of problems. So some might block a hacker, some might block a virus, things like that. So you want to have a firewall. No matter whether you're using a VPN or not, you want to have some kind of firewall. You want to have endpoint protection, which is your antivirus or malware. You want to have some kind of password management, something like 1Password or LastPass, something like that, where your passwords are automatically saved in an encrypted environment, and you can pull them out if you need to. Multi-factor authentication. And multi-factor authentication is available on Office 365, and you can implement it sort of easily. I did have to get my IT guys in there to help me out. But basically what it does is it not only are you going to use your password, but if you are going to access your information on a different computer than you normally do, so it's not every time you log on to Outlook, but if I'm logging on to Outlook on my sister's computer, it's going to say, are you really Diane? And it's going to send me a code very, very quickly to my phone, and I'm going to have to enter that code so that it knows that I am logging onto my Outlook on a different computer than I normally log into. So it's not like you have to log in and use a code every time. There are certain things that are set up that way. Your bank should be set up that way, but most things that you use every day, like your security on your Office 365, is just when you're using something different. Disk encryption is very important. You should have a Windows version that is professional if you're using a PC, and you should encrypt it. It's BitLocker, and that's part of a Windows feature. If you are putting anything on a thumb drive or a DVD or CD, you can encrypt those also with this feature. One of the things that's important when you're buying software is to always, always, always buy the professional version. What I've done is, I'm going to buy the home version, and then you go to do something with extra security and you realize, now I have to upgrade it because what I need to do to secure my business is different than what I need to do to secure my home information. So I always recommend my clients to pay the extra few dollars and get the real software that is created for businesses and allows you some of these security things. We already mentioned security awareness training for employees, having conversations, letting them know that other companies have been hacked. When you hear, even when you're talking about Target getting hacked, sitting there and talking about it, talking about what you can do to make sure that doesn't happen for you. I don't think that attorneys should save credit card information. There are some people that save credit card information and will refresh their retainers every month with a credit card. There are ways to do that without having the client's credit card information. So look for those kinds of things. Get cyber insurance. The firm that we worked with, I think their policy was $2,000 a year, and their share of, without legal fees and without paying for us to help them get everything back up and the extra IT, that was all, would have cost them about $200,000 just to get back to ground zero. And if they didn't have that cyber insurance policy, that could have been a real problem for them. And it can put law firms out of business. It actually did put the third-party IT company out of business. Always have a backup and a disaster recovery continuity solutions. So what I'm talking about is not only backing up your computer, or sometimes you'll have a backup, but you need to have the software in order to use that information that you've backed up. So make sure that when you have a backup that you know how to access that information quickly. So you have a backup, you're saving it into cloud, you know, go to somebody else's computer and try and access it and use that information. You want to be able to get that information quickly and have access to it. You don't necessarily want to have to contact an IT company who then has to create a server, put your information on the server, and give you access to it. So again, thinking about what would happen if you needed to, quote, unplug your computer, how would you get your information, and how you secure your information while it's coming and going. So there's all of these different layers of things that need to happen for any size company to make sure that you are securing your information and your client's information.
Diane, just real briefly, I think all of these recommendations are excellent, but one I want to highlight for the group really is this idea of cyber liability insurance. You know, there is a real need in today's world, and I recommend for every company of every size to get a standalone cyber liability insurance policy. You know, about 6 months ago, I had a solo CPA walk into my office. He was in the midst of a ransomware incident where the bad guys had gotten in, locked up all of his information, and then demanded an outrageous sum of money to unlock it. And the first question I asked him was, do you have insurance for this? And he produced a CGL policy which clearly excluded anything related to electronic data, computer systems, et cetera, et cetera, et cetera. And he was stuck. Now, he may have had some other ways, recourse methods, but they weren't great either. So again, this highlights really the need to have cyber liability insurance. You know, one question that I always get is, what cyber insurance companies do you recommend? I personally am a big fan of the London-based market. I believe it's more advanced by and large than the US domestic marketplace. One exception that I think is interesting for small businesses to look at is a company up in Northern California called Coalition. Highly recommend checking out their site because I think they have a very interesting and unique approach to this. But you need to remember, because this cybersecurity, the technology is evolving so quickly, the insurance policies and the carriers are trying to keep up with it. And I can assure you, having analyzed dozens and dozens of cyber policies, not all cyber policies are created equally. Because they're so new, there aren't established forms that permeate the industry. You really need to take a close look at your cyber insurance, particularly in the midst of this COVID-19 pandemic, because with everyone working from home, there are some policies that exclude coverage for work from home devices that are not owned by the company. And social engineering, we've seen that go through the roof. Phishing exercises, which you've heard of in the past, you need to make sure that you have ample social engineering coverage. So again, I can't highlight enough and encourage all of you to make sure you have cyber liability insurance and make sure your clients do as well. Thanks, Diane.
Sure. And you can talk to your regular normal insurance broker and tell him or her you want them to look at the London market, or you want them to check out this other insurance company. You don't have to, you know, we have to know what we're doing. We have to know what we're covering. So make sure that you're communicating what your needs are to your broker if you have one as well. So when I look at software for law firms, I always look at web-based software, meaning that I can get onto that software from anywhere. I don't have to be on my computer. So I can go to any URL and I can log in like you can to Outlook if you have Office 365. So you want to, if you're looking at software, you want to look at several different things. You want to look at where your information is and who houses your information. So meaning that some software companies have their own data centers. You should know kind of where your data is stored, what it's stored on. Is it sitting in somebody's garage because it's a local software company and they have put out this really great product, you really like it, and their data center really is just somebody's house. Is that going to be sufficient for you? You should know what security is being applied to your information, even if it's quote in the cloud. Remember, the cloud is not a cloud. The cloud is a server somewhere that your information is being held on. So you want to know who houses your information and where it is so that you can have access to it. You want to know if you want to find out if you're one of the software companies that you're looking at and learn about their security, they should have something on their webpage that talks about security. It should be something you can search for on their site. And I've noticed if I can't search on a site, a lot of these software companies, all they do is say, oh, click here for a demo. If you scroll all the way down to the bottom of their homepage, there's usually menus down there and you can usually find security on there. Click on the security and find out, read about it, and see if it's acceptable to you, what they're doing and how they're doing it, how it's stored, what the backup situation is, if the data is encrypted in transit, you know, if you attach a document in Outlook, if that document is encrypted, or if you need to have some kind of encryption software for your Outlook, things like that. And then one of the things that is important is if you get audited, and people do get audited, you might get a client, even if you're a small firm, you might get a client that is a credit union or a small local bank, and they have certain requirements for their information and data, and you don't want to turn away clients because you don't have the security and the needs, you're not meeting their needs for securing their information. So what I like to do is understand from an audit standpoint. So if the bank comes in and wants to do an audit on how you're saving your information, I can hand that audit to my software company. So for example, if you get audited, and I know that from experience that NetDocuments, for example, is a document management system, and I don't like to specify specific software or recommend specific software for everybody in the market. However, I do know that NetDocuments is a company that has its own data centers. And if I get audited, if somebody comes in and hands me the audit information, I can work with my IT folks and I can work with NetDocuments, and NetDocuments will do the tour of the facility and will do send information. I work for the city of, do work for the state of California, and they wanted to know XYZ. I called NetDocuments and they sent the information to them. So being very careful about what software programs you're using is important, and knowing what questions to ask is important about security and having access and getting audited. Anyway, that's my 2 cents on looking at software. And not just purchasing something that looks really good and it's the neat thing that that the guy down the street developed. So I'm gonna send it back to Ericka if I can.
Yes.
There you go.
Thanks, Diane. That's helpful. Yeah, just to add on to what you were saying, you know, even if you aren't the one in your firm deciding what software products to use or web-based services to use, make sure you understand what your firm is using, because clients will ask. I have clients, you know, potential clients call and they say, what do you use to send documents securely? What do you use to encrypt information? And you need to know the answers to that. So it's important to know what you're using, even if you weren't the one to decide. Okay, moving on. Using software and web-based services for your specific clients. Research, we all know Westlaw, Lexis. There are, several firms out there who still have libraries, and that's fine if you like hard copies, but especially after COVID, we are getting to the point where I think a lot of attorneys are going to be reevaluating how much office space they really need. And do you want to be filling up your office with physical books when you could be getting everything online? If you're looking for discounts, go to your bar association. Oftentimes, bar associations will partner with various online research platforms, and they'll offer discounts. And if they aren't offering any collaboration or discounts, ask your bar association. I've been on the board of the Contra Costa Bar for 6 years now, and oftentimes we don't look into things until a member tells us there's a need for it and ask us, hey, can you see if you can get a discount for this? And we'll look into it. So ask your bar association. Regarding practice specific online resources. So just examples of what I have encountered. I'm a business law attorney, a real estate attorney. So in those realms, oftentimes you can get things for free. The SEC, they put on their website all contracts and documents that have been filed with them by publicly traded companies. So what does that mean? Well, there's a huge database of good contracts that are available for free. So if you're ever looking for an example, go to the SEC's website. For real estate attorneys, almost all escrow companies and title companies will offer attorneys access to their database of recorded documents for free. You just have to ask. They will give you credentials to log into their platforms to be able to pull deeds and other things like that for free. So whatever your practice area is, ask questions and figure out how to get the information that you can then use to help your clients. Diane talked briefly about this, document management. Document management is a word that not everyone knows what that means. To me, document management is a program to keep your documents, to be able to search them and find documents easily. For example, if I am looking for an example of a complaint that includes a specific cause of action that was drafted between X date and X date, and it was drafted by so-and-so attorney because I know that that attorney prepares great complaints, then I can put in all of those search parameters to find it. Oftentimes I'll speak with solos and smaller firms, and they don't have document management programs. They say, well, I know where everything is. I can go on my computer and I can find it when I need it. That's fine if it's just you, but if you ever want to be able to find things that other people have prepared or prepare your firm to expand or transition, then you want to implement a system now in order to save your documents so that others can find them. Case management, what I would say is know your programs. For example, my firm uses Clio. A lot of times what I've experienced is that smaller firms will have certain services that they use, but all of the attorneys won't have done the training on it. They'll rely on the staff to do the training and hope that their staff tells them everything that they need to know. I think you need to do the training. You need to learn the ins and outs of the software that you have available to you so that you know all of its capabilities, because all of these programs out there really do have quite a lot of capability, and you won't know it unless you look into it.
Can I just add something there as well,
Yes.
Ericka? When I'm working with clients, there are times when they're looking for a certain kind of software, they're looking for recommendations for this or that, and they have software already that does what they need it, what that feature is, but they haven't learned it and they don't even know that that's what the software does. So again, before you start purchasing software, make sure you understand your software and know what the features are. And if you don't, then contact them and say, does it do XYZ? And before you start purchasing extra add-ins or things like that.
Yes, thank you. I agree. Okay, moving on to the next slide. Oh, there we go. Okay, one of the most important topics for your firm is the money. You need to be making sure it's managed, and how can you use technology to make that happen? Financial reporting. What I would say is, from the outset, you need a bookkeeper. You need someone who is going to track every dollar that comes in and goes out and report it properly. Why do you do that? Well, because it'll make your accounting each year cheaper. If you go to your accountant every year to prepare your tax return and your books aren't in order, it's going to be an expensive endeavor to prepare your taxes. So from the beginning, do your books, do them properly, implement procedures between everyone you work with so that everyone is providing the backup and the data to whoever is doing the books. And that way you can implement automated processes so it's cheaper in the end. Two things that sort of go together: billing and collecting. As Diane was saying, know your software. A lot of billing softwares that are out there for you to put your time in, track time, they have so many other capabilities. For example, you can put in procedures to put in budgets for specific clients. And if you exceed that budget, then everyone will get a notification so that you're aware that you're reaching that limit. There are lots of features that you can do, so know your software. Collecting, what I would say is, in my experience, the quicker you generate invoices, the quicker you're going to get paid. If you do an assignment for a client and you don't get a bill to them for over a month, 2 months, by then they've forgotten about it. And so they're gonna get the bill, it's gonna sit on their desk, or it'll come in their inbox, hopefully electronically, and they'll have to think back, oh, okay, what did we do? Let me get back to this. In my experience, the quicker you get bills out, the quicker you get paid. And so moving on to the next topic, payables. The easier you make it for a client to pay you, the more likely it is you're gonna get paid quickly. And yes, that costs money sometimes. For example, accepting credit card payments. Yes, you will be paying the credit card fees, but I would rather pay the credit card fee than have a bill go uncollected for a while and to spend time reaching out to the client asking for payment. Lots of clients don't like to do credit cards, they want to do checks. Well, offer e-checks. You can still electronically send payment using a check if they don't want to put it on their credit card. So I like to make it as easy as possible for my clients to pay me. Okay, next slide. Using technology to grow your business. Just a few examples of platforms that are out there: LinkedIn, Facebook, Instagram, Twitter. Have a presence. Someone in your firm should have a page on each of these for your law firm. And it's just to have a presence. In my experience, it's not necessarily the main way to get new clients. It's the way to remind people that you already know what you do. If I am constantly posting as Ericka McKenna, business attorney, and I'm posting frequently, people are going to see Ericka McKenna, business law attorney, pop up in their feed over and over and over. So when they're talking to someone who needs a business attorney, if they just happen to see Ericka McKenna, business attorney, recently, I'm going to be top of mind to them. They're going to remember, oh, I know Ericka. I think she's a business attorney, and they're going to pass my name on. So in my experience, you can use these platforms just so that you stay top of mind to people that you already know. Okay, next slide. Online advertising, it's very popular right now, especially with COVID and sheltering in place. People are finding new ways to reach people. And all I would say with this is try it, but monitor it. Make sure that it is generating the leads that you desire and that it's worth the cost. And you may have to play with it and do it different ways, and it may not work at first. So I'm always a proponent of trying new things, but monitor it to make sure that it works and understand how it works. Know that with Google Ads, you're paying per click. What does that mean? If you Google your firm's name and your ad pops up, don't click on the ad because you will then pay for that. Go to the organic bar and type in your website and go to it that way. Don't charge yourself for advertising. Okay, next slide.
Ericka, have you used Google Ads?
I have.
And just generally, what does something like that cost? Like you saying you pay per click.
Yeah, so, interestingly enough, and I don't know if this is as a result of the pandemic or not. So my firm, we were doing Google Ads before the pandemic for my practice area for business formations. Now, right before the shelter in place, we hired an estate planning attorney. So once shelter in place started, we decided to start doing Google Ads for estate planning. I noticed a huge difference in cost from what we were doing before versus now. And I don't know if that's because of the different practice area or if it's because Google Ads might be more expensive now that more companies may be advertising online. But just to share, so how it works is Google will recommend to you how much you should pay per click. And it's a whole algorithm, and you can dictate. But if it says, hey, we recommend that you pay $5 per click, and you say, no, I only want to pay $1 per click, well, then your company may not come up at the top of the list because there are other companies out there paying $5 per click. Okay. So you set the amount, but Google will recommend to you how much you should pay. So as an example, when we were paying for business formations, I believe we were paying about $5 per click. Now with estate planning, it's recommending $25 per click.
Wow. Wow. Okay. Thank you.
Yeah. Okay, your website. There are different reasons to have a website. I sort of put it into two main buckets. One is to legitimize your business. If someone already knows you, they know your name or they know your firm's name and they want to read more about you, they're going to go to your website to see who are you, what specifically do you practice, how can I contact you? So that's one bucket that I see is to legitimize who you are. The other thing that I see your website for is to get new clients, to get people who don't know you to find you. So there are different ways to do that. One is with SEO, with your search engine optimization. You need to be putting in words when someone wants to find a business law attorney in Walnut Creek. Well, I'm going to work with my SEO partner to make sure if someone's typing in business law attorney Walnut Creek, that my website's going to pop up. But it's not just, an easy formula. You have to constantly be adding content to your website in order to be popping up. It's not just putting in terms in an SEO platform. It's also adding content to your website. And then branding, just one thing I would say with that is make sure that you're consistent. Make sure that your branding on your website matches your branding on your signature of your email, matches your branding of everything you put out there for you and your law firm. So I think that was it that I had.
Does anyone have any questions, or do any of the panelists have anything they'd like to add before we finish up? We have some time. Looks like we've been answering the questions as they've come in. I guess one question I would ask Jeff is, are there recommendations that you would make for people when they're purchasing software to keep in mind, or when they're retaining somebody that's going to house their information?
Well, I mean, I think the most important thing you can do is take a very close look at whatever your written agreements are with either a new software company or, for instance, a cloud storage company or a hosting environment. You need to make sure that you are protected as a client. You need to make sure that they have appropriate technical security in place. I often encourage, obviously, strong indemnity language that goes without saying, as well as a right to audit if they, if they have a security system in place. Upon your request, you need to be able to audit their security system or have a third party come in and audit it. Again, what you're trying to do is to protect yourself and whatever data you may have to the best of your ability. And obviously, risk transfer is the chief way to do that.
Great, thank you. Any other questions? One of the questions is, how many software companies will even allow you to change their terms? None. Well, you have to be a big company. I don't know if somebody on this call would be able to have somebody change their terms, but Jeff probably can speak to that.
It depends on the software company. It depends on who your company is. Obviously, you're probably not going to be able to negotiate a whole lot of change in terms for companies like AWS or Google, but there certainly are things that you can do, and we've negotiated a number of contracts with third-party service providers where we are able to go in and add things, add protections in. Again, you're never going to be able to do that with the massive companies, but that's sort of comes with the territory. That's the risk you run.
Great, thank you. Well, I think that wraps us up, unless David or Ann, you have anything that you want to add at the end of this session?
No, just a great big thank you. So much really good information. I was taking notes the whole time. So really great. Thank you all very much. A lot of hard work, and I know this is going to be great for our members. So thank you.
You're welcome. Great.
Yeah. We do have a question that popped up as far as where we can get the presentation materials, and the bar will be sending all of those out. So Ann will be working on that. You should have those in the next couple days. And then they will also, when we make this presentation available through the bar's website, all of the materials will also be available for download when you watch the video. So I don't know, Diane, I know we have your presentation. I don't know if there were any other documents that went with that, but Ann will be putting everything together to go out to everybody who's registered.
Yes, there's one other list that I've been sharing that is just a list of legal software types, and then underneath each type is a short list of different companies that provide that type. So it's not a recommendation of any one software company, but it has information. It has like a starting point for people to look for software. That's going out also with this presentation slides. Okay.
Thank you, everybody. We also want to remind everybody that our next education seminar panel is coming up via Zoom on May 29. So That one, I believe, is at 9:30 in the morning. So hopefully everyone appears for that as well.
Thank you. Thank you, panelists, for sharing all of your information with us.
Thank you for having us.
Our pleasure.
Thank you.